Hi, my name's Michael Barber, solicitor with Dundas Lawyers. Dundas Lawyers is an award-winning corporate, intellectual property and technology law firm that also passionately litigates in these areas. Today, I'm going to discuss domain names. I'll give you a brief overview of what they are, what the allocation and eligibility rules for domain names are, and how disputes over domain names are resolved. A domain name is simply a string of characters which uniquely identifies an IP address on a computer somewhere which hosts a website. An example is dundaslawyers.com.au. The .com.au part of the website is what's known as the top-level domain. There are typically two types of top-level domains. Country code specific top-level domain, like .com.au, and generic top-level domains, like .com and .edu. Domain names are necessarily unique, and when somebody types in to a browser something like www.woolworths.com.au, they know exactly where they're going to end up. It wouldn't surprise anyone if a dispute arose if they ended up at the Aldi website. Now that typically doesn't happen. And the reason it doesn't happen is because there are specific requirements that you must meet before you can have a domain name. Those requirements are set out in the domain name, eligibility and allocation policy rules. The policy sets out the rules for the .au domain names. Essentially, there are two sets of rules, those that apply to the .au and those that apply to second-level domain names like .com.au or .org.au. The rules that apply to all .au domain names are essentially that the registrant has to be an Australian and the domain name must consist of at least two characters, being alphabetical, numerical, or a hyphen. The second level domain names depends on what domain name we're talking about. The .com.au is used for commercial purposes. If you want to register a .com.au, you have to have some sort of business structure and or a trademark. That business name then can be an exec match, an abbreviation, or an acronym. Of course, these rules are a little bit more complicated than that. But you may have gathered, Jim's Mowing and Jim's Bakery would both be eligible to jims.com.au. These rules are by no means perfect, and given the simplicity with which you can register a domain name and the value that that domain name can be to the business, it's very common that disputes arise between individual parties about whether or not one has the right to a domain name. There are a range of causes of action that come about from domain disputes. There may be a trademark infringement, there may be allegations of passing off, and proceedings can also be brought under the consumer law. Probably the most common, though, are actions brought under the Uniform Dispute Resolution Policy. There are a number of dispute resolution policies, one for the generic top-level domains, and the country codes may each have their own dispute resolution policy. As such, the .au domain, our domain, has its own dispute resolution policy. Certain organisations throughout the world are authorised to hear disputes. The World Intellectual Property Organisation is one that can hear Australian domain disputes. And of course, to make things a little bit more complicated, they've issued their own procedural rules. To succeed in a dispute over a domain name, you need to satisfy each of three criteria. You need to show that the disputed domain name is identical or confusingly similar to your name, trademark or service mark. Secondly, you need to show that the registry has no rights or legitimate interest in the disputed domain name. And finally, you must show that the domain name has been registered in bad faith and subsequently used in bad faith. I'll speak a little bit more about each of these in a later video. In the meantime, if you're looking for a technology-savvy lawyer to advise on domain disputes, please don't hesitate to contact us on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching.